Hello, my name is Anne-Sofie Rasmussen and I'm an associate at Danish law firm Kromann Reumert, where I'm part of the team working with copyright and media law. I want to thank the UNESCO Information for AI program for the opportunity to give this short presentation, which will introduce a Danish legislative proposal which incorporates protection against deepfakes in the Danish Copyright Act. I will start out by briefly introducing the proposed protection against deepfakes and its placement within the existing framework of Danish copyright law. Then I will outline the existing protection against deepfakes under Danish law and explain the considerations informing the proposed update of the legislative framework. After this, I will explain the content of and limits to the two types of deepfake protection proposed. And finally, I will address some of the potential shortcomings of the proposal. So different countries are adopting different approaches to the dissemination of deepfakes, but as far as I'm aware, Denmark is currently the only country using copyright law as the legal framework. The proposed Amendment Act, which has not yet been presented in Parliament, it's only just finished consultation, will introduce two types of protection against deepfakes in the Danish Copyright Act. The first is a general protection applicable to everyone against the sharing of realistic digitally generated imitations of their personal characteristics, such as appearance and voice, without their consent. The second is a protection of performing artists and other performers against the sharing of realistic digitally generated imitations of their artistic performances without their consent. At the same time, the existing protection of performing artists in the Danish Copyright Act will be expanded to also include other performers. At present, a performing artist is defined as someone performing an artistic or literary work, and with the proposed change, artistic performances of material that does not enjoy copyright protection will also be protected against recording and imitation. If it's adopted, the Amendment Act is expected to enter into force at the end of March next year. So to clarify why the Copyright Act was chosen as the basis for deepfake protection, I'll just briefly outline its current scope. So first, it protects literary and artistic works that meet the originality threshold for copyright protection. Second, it covers related rights, including the protection of performing artist performances and photographs which are not protected as artistic works. This is where the deepfake protections for performers will be included. Finally, it contains provisions for protecting titles of literary and artistic works to avoid confusion with other works. The general deepfake protection will be placed here. The Copyright Act was chosen as the framework for the new protections against deepfakes due in part to their overlap with the existing protections in the Copyright Act, and also because the Copyright Act already protects the material used for deepfakes, such as portrait images and recordings. And also placing the protections within the Copyright Act will give deepfake victims access to the same remedies as victims of copyright infringements, which include reasonable remuneration for the exploitation of their rights and damages for additional damage and compensation for non-financial damage. I will now briefly outline the existing protection against deepfakes in Danish law. So first of all, I should clarify that when talking about deepfakes in the context of both the existing and the proposed regulation, what I refer to is AI-generated or manipulated image, audio, or video content that replicates an individual's personal characteristics such as appearance, voice, and movements, and which would falsely appear to be authentic or truthful. As such, the definition is aligned with the definition of deepfakes in the AI Act. In Danish legislation, a partial protection against becoming the subject of a deepfake can already be derived from various provisions in criminal law, in marketing law, in the AI Act, in privacy law, and finally in some non-statutory name and image rights that are established through case law. And the new protections will supplement rather than replace this existing regulation. So why does the current framework not suffice? So generative AI, of course, now allows anyone with online access to create a deepfake, and this leaves particularly performing artists and public figures exposed to such infringements. This not only harms the individuals in question, but also threatens democratic dialogue by eroding trust in information. Furthermore, deepfakes can spread very rapidly, of course, on content sharing platforms, which necessitates a clear basis for activating the takedown obligations pursuant to the Digital Services Act on such platforms. And the new protections are intended to provide such basis. I will now outline the content of and the limits to the protection. So the general prohibition against deepfakes has a duration of 50 years from the death of the individual being imitated. The prohibition does not apply to the creation of deepfakes, only making them available. And the prohibition does not necessitate intent, but also applies to negligent or even accidental disclosure. The general protection against deepfakes does not encompass imitations that are primarily expressions of satire, parody, pastiche, social criticism, political criticism, and such. The limitation in that way reflects Article 10 of the European Convention on Human Rights, in that it concerns some forms of expressions that enjoy a particularly wide protection under the convention, as opposed to, for instance, purely commercial expressions. It acknowledges that a deepfake may, in some circumstances, be protected as an artistic expression that constitutes commentary on issues of general public interest. The second part of the provision reflects that such deepfakes may only be restricted in exceptional circumstances where the imitation constitutes misinformation that poses a real danger to the rights and interests of others. The protection also excludes material that has been clearly labeled as AI generated, because this eliminates the risk, of course, of confusion with real content. So the deepfake of protection of performing artists and other performers is quite similar to the general protection, as it also has a duration of 50 years from the death of the performer and does not extend to the creation of deepfakes, but only making them available. But unlike the general protection, the protection of performing artists and performers provide for direct liability for online content sharing platforms through incorporation of the Danish implementation of Article 17 of the DSM directive, according to which these platforms perform an independent act of making available to the public when they give the public access to copyright protected works or other protected subject matter uploaded by its users. So the deepfake protection of performing artists and other performers is limited through reference to the existing exceptions to copyright protection in the Copyright Act, which incorporate the exceptions that are provided for in the InfoSoc directive, and also includes exceptions for satire, parody, and pastiche. The limits to the protection as such balances rights holders' interest in protection against considerations of freedom of speech and information, and as such also reflects Article 10 of the European Convention on Human Rights. Provided that the proposed amendment act is adopted, it does raise a number of questions as to its practical efficiency and enforceability. These include both issues related to interpretation, jurisdiction, and enforcement setup. So as regards the interpretation issues, the law requires that the imitation must be realistic, meaning that there is a risk of confusion with an actual performance or a person. This excludes digital drawings or imitations that has fantasy elements added to them, such as like the skin is green or it has elf ears or something like that. Additionally, the protection only applies to artistic performances, which means that the performance must have an intended aesthetic or artistic character, and this will exclude, for example, sporting performances that are based solely on technical skill. In practice, it may, however, be difficult to clearly define these concepts due to their subjective nature and their discretionary elements. So it may also be questioned how effective the protection against deepfakes will be in practice. Typically, individuals seeking remedies for copyright infringements must pursue legal action, which is of course often costly and time-consuming. The proposed amendment does give courts the power to order removal of infringing content from platforms, but for private individuals, litigation of course remains a significant barrier. So the effectiveness of the protection is very much dependent on the compliance of platforms with their takedown obligations, And furthermore, given the national scope of the Danish Copyright Act, removed content in Denmark may still be accessible from other countries. So it remains to be seen whether the Act, if it is adopted, will actually effectively address the problem of deepfakes. This was my short overview of the planned introduction of a deepfake protection in Danish copyright law. Thank you very much for listening, and do feel free to get in touch if you have any questions. Thank you.